common law duty. There was a common law duty. I am addressing to the admin body. There was a common law duty to act fairly on part of the board. You have to act fairly. I would quash the decision of the admin body. I would quash the decision of the admin body because what was your decision? Not to provide right to counsel in a hearing. That was your decision. I would quash this decision and send it back for re-hearing. In the hearing, you must provide right to counsel based on common law, not based on act, subordinate legislation, policy and guideline. Because there was no violation of act. Act is saying nothing is silent. Subordinate legislation is silent. Policy and guideline is silent. If your policy and guidelines say, if, for example, if your policy and guideline must provide right to counsel, then I'm gonna say not common law duty. Under the policy and guideline, you made your own policy and guideline, and you are not following your policy and guideline. I would quash the decision of the admin body based on, because serious violation, you made your policy and you are not following that policy. Based on this step, I would quash the decision of the admin body, not based on the common law duty, based on the on policy and guideline. You made a policy and guideline must provide right to counsel, and you did not provide. Quash the decision of the admin body, send it back for re-hearing. Procedure is done. Make sense? Computer guys, make sense? So basically, one is under the act, subordinate legislation, room number 2, act, subordinate legislation, policy and guideline. If violation of the act, you are admin body. Violation of the act, it means violation of the act. Violation of the subordinate legislation, violation of the subordinate legislation. There is no common law duty. Violation of the policy and guideline, you made your own policy. You made your own guidelines. Now violation of your own policy, I would quash the decision of the admin body based on your own policies. In a given scenario, you made a policy, you must provide right to counsel. There was a violation of your own policy, I would quash the decision of the admin body, send it back for re-hearing. But there is no violation of the act, there is no violation of the subordinate legislation, there is no violation of the policy and guideline, then common law duty. Why common law duty? First, I established in an administrative law, decision of the admin body was admin decision, not legislative decision. Common law duty. My being a judge, my duty was, you know what, admin body, your decision is not a legislative decision. If your decision is a legislative decision, I'm not going to jump into your decision. But in a given scenario, your decision is a administrative decision. I have to jump into. Who am I? Judge. I have to jump into, because your decision was an administrative decision. Number 1. Number 2. Okay. Common law. Room number 3. Importance of the decision to individual. Importance of the decision to individual. You know what? Decision is very important. Reprimand, suspension, $25,000 to $250,000 fine is a bread and butter, big stigma of his life. Suspension of the lessons, how he gonna pay mortgages, serious issue. Based on there was a serious violation of the common. At least some level of procedure fairness is required under the common law duty. I would quash the decision of the admin body, not because of against the violation of the act, not because of the violation against the violation of the subordinate legislation, not because of violation of the policy and guideline, because of under the common law. Whole procedure is done. If you're gonna go tomorrow in the exam, maybe you're gonna get 30-40 marks out of 50 marks. Last year 67% marks came from procedure. If yes, 67% only from the procedure. So if tomorrow you're gonna write, you never know tomorrow you are passed. Sometimes 50 marks question, sometimes 50 marks question. Highly chances you're gonna get 35, 40, 45, maybe 50. You got it? So procedure fairness. A computer guys, do you have any question? Yes, we have to write case law. Exactly. Possibility, I have written every case law in my IRAC. If you're gonna read, if you're gonna join my regular class, these okay. You know what? Okay, first of all, okay, if you wanna continue my class, I love it. If you will not continue my class, still I love it. Feel free to ask me now. Now before legitimate expectations. Now my promise. Doesn't matter you gonna retain my services, you will not gonna retain my services. Feel free to ask me any question at any time. Doesn't matter you are my student, you are not my student. But I would not share my 11 pages to those who are not my students. Of course, only for my regular class students. Everything I have written according to, for example, I have written cane. If you are fired from the job, cane is here. Cane is here. Where is the cane? Just one second. Just one second. Just one second. See, R versus cane, right? Cane is here. Okay. Fure is here. Expectation. Fure is case. Singh case. Khan case. University of Ottawa case. Okay. Pushpa Nathan case. Every case I have already mentioned. 8, 9, 10 cases which are very important, I have already mentioned. Just what will you do? Which okay. For example, okay, example. Importance of the decision. One paragraph, second paragraph. Or there are 3 cases. Which one is relevant? You have to pick up that line into your examination sheet. You got it? You will not gonna write everything. Oh, you know, this para is relevant. This para is not relevant. This paragraph is relevant. This paragraph is not relevant. Which is relevant? Pick up that paragraph from my IREX, write into 90% question is answer is right here. 90%. Concept should be in your mind. Then you're gonna solve the exam question. Makes sense? Do you have any question regarding procedure? That's why I always call 24/7. I know in my class, people, they don't need to call me. That's why I always call. I'm 24/7 available because in my class, I do justice, more than justice. No one gonna, in like very small number of people keep calling me. Those who have some problem with the net or something, this one. That's why I always call, call 24/7 because in my class, no more left, no reason to call me. But still you can give me a call. Procedure is done. Okay, then we have to, okay, bias. Just 2 or 3 minutes of bias. Okay, in bias. Computer guys, bias. Tired man?
I am.
Yeah.
No, I'm okay.
It's a boring class. Computer guys, it's a boring class.
No,
Ekvita, I have written every, don't worry about average, how many cases, law to cite, average, how many cases? 5, 6 cases. Maximum, Kavita, maximum 5 cases. 5 cases. Baker is very important. Dunsmuir is very important. Khan versus University of Ottawa is very important. Okay. Singh is very important. Pushpanathan is important. That's it. 5, 1 or 2 more cases. I already mentioned. Everything would be covered. Where is the bread and butter? Cane. Where is the deposition order? Singh and Dunsmuir is the same contest. Dunsmuir, she was living in Canada for last 12 years. She didn't go back to this country. 2 people were born in Canada. Okay, same. She was not terrorist. Singh was not terrorist. Same facts. Everything is same. Principle is same. But in Pushpa, nothing is little different. If he gonna stay in Canada, threat to national security. Send it back to Sri Lanka. Her life is infringed. Liberty is infringed. Mental torture. Oh, tomorrow I would be in Sri Lanka. Same thing. Mr. Singh case is different. If he gonna stay in Canada, it is not threat to the national security. But if we gonna send it back to his country, India, highly chances his life would be infringed. Liberty, of course, liberty is going to be infringed. Security, mental torture. Okay, bias. Bias in the hearing. Even bias can be in paper hearing, can be in oral hearing. There are two kind of hearing. One is in an exam. In the exam, this time, not this time. I mean, just giving you example. Okay, I mean, you will see, you will get oral hearing. You will get oral hearing. No, you will get